right. Hello, good afternoon, everybody. So if the power of technology is with us, also the people online should be hearing my voice. In case this is not happening, please write in the chat so that we can panic and try to do something about it. Anyway, if this is working, so good afternoon, everybody, and welcome to the European Birds of Passage seminar on temporary labor migration and domestic work in the EU. I am Marco Rocca. I am the principal investigator of European Birds of Passage, EBOP for friends, and it is my pleasure to welcome our speakers and you all, whether physically or digitally, to Strasbourg. So I will not take too much time before giving the floor. Let's also admit other people. Before giving the floor to our first speakers, just a few words of introduction on the link of today's topic with the EBOP project. At EBOP, we focus on social rights of temporary labor migrants, both moving to the EU and inside the EU. So today we will have a presentation focusing on both these categories. And because of our focus, we are sometimes a bit weird in our choice of terminology, as we like to speak of migration for both intra-EU and extra-EU movement of workers, whereas lawyers often prefer to distinguish intra-EU mobility and extra-EU migration. Our project focuses on fostering a scientific dialogue between legal research and empirical data, which has led us to focusing on several sectors. Domestic and care work is one of those, which leads us to the present day. In terms of practical organization, we will have the 4 presentations, one after the other, and leave the discussion and questions at the end so that a dialogue can also be established between the different presentations. Of course, do not hesitate to write your questions in the chat if you are online, or you can raise your hand and we will give you the floor, hoping again that technology is with us. And with that having been said, it is my pleasure to give the floor to our first speaker, Vera Pavlou. Vera is senior lecturer at the University of Glasgow and the author of the book Migrant Domestic Workers in Europe, Law and the Construction of Vulnerability, published by HUD in 2021. Vera, many thanks for accepting our invitation, and the floor is yours, and I will share your presentation.
Thank you very much, Marco. Thank you very much to everyone for being here, and especially to the team for inviting me. It's a real pleasure to be here today to talk about migration and care work, and to listen to your presentations as well. So the topic I will be talking about today is care work and migration, focusing specifically on EU law and policy and what could probably be done at the EU level in this area. So first of all, an outline of my presentation, which will be around 20 minutes. So first I will sketch the problem with care work, the legal and socio-legal issues in relation to care work and migration. Then I will briefly talk about what role is there for how law contributes to some of the problems we will be discussing, both at the national and EU levels. And then I will give a discussion of the European Care Strategy, which was adopted in 2022. And then finally, I will conclude with posing some questions about possible ways forward for the EU at the legal and policy level. So, is it here? Yeah. Oh, okay. Okay, so first of all, just to start by saying that care work, both its unpaid and paid forms, it's fundamental in any society. It's at the heart, it's what keeps society together. There are multiple forms of care work that need to be done in order to keep society together. So it's a very important aspect of life. What we see in the EU in the last decades are increasing needs for long-term care, and this is a phenomenon that we see everywhere in Europe. I think in every EU member state, there are needs for people to be cared for on a long-term basis, so not a one-off thing, but needs to have care arrangements both for children, for the elderly, for disabled people on a long-term basis. Just to give an illustration of that, according to estimates that one can read in the 2021 Aging Report, by 2030, it is estimated that there will be 33.7 million people in need of long-term care in the EU, and that number is expected to rise to more than 38 million by 2050. So we understand that we are talking about a very large numbers of people needing care on a long-term basis. So the situation is that in Europe, what we see today is a heavy reliance on different types of privately hired workers to provide both direct and indirect care needs. Just a note here to say that I use care and domestic worker interchangeably. I understand some people might see this see different descriptions in the term of care work, which is often associated more with the provision of direct care, so taking care of a person, bathing them, feeding them, cleaning them, and so on. And domestic worker, which is often more associated with indirect care, so providing cleaning or other services that households need. But for the purposes of my presentation and in my work in general, I use the term domestic and care worker interchangeably because I think that often in reality, aspects of direct and indirect care are present in these paid caring relationships, and it's not always difficult to distinguish between the two aspects. So of course, because of this reliance of hiring care workers privately, so we have private individuals becoming employers, private households becoming workplaces, which is something, a phenomenon that the standard labor laws and institutions that we have in labor law are not always attuned to address. You know, this idea that the employer is not a company, it's not an employer, but it's a private individual, and that the private household becomes the site of work. So when I talk about care workers, I mean anyone who works for or in a private household providing services to that household. We are talking about a large sector at the level of the EU. So according to statistics, what this term that it's used in EU policy, personal and household services sector, accounts for around 5% of total employment in the EU today. So we are talking about a significant sector, and this is just numbers concerning declared workers, not the undeclared part of the sector. Okay. Now, a little bit on the profile of the people that provide this work. So I think the statistics will not surprise you. We are always talking about working class people that provide care work, and they are very often migrant and very often also women. So again, to illustrate this with some statistics, women make up more than 80% of the care work in private households workforce in all European states, so more than 80%. And in some forms of domestic work, such as living employment, so people that live in the employer's household, the share of women can be up to 90%. For instance, this is the case of elderly care in Germany. We have people on a variety of migration statuses, third country nationals, so non-EU migrants that may hold different kinds of temporary permits. We have intra-EU migrants that again can be under different arrangements, posted workers or migrant workers that settle from one EU member state to another, and so on. Informalities, again, very extensive. We have, again, according to estimates by the European Labour Authority, around 6.8 million workers who are undeclared. And this is half of the estimated workforce. So almost 1 every 2 domestic workers are undeclared workers. So all these factors, they give rise to very important decent work deficits in care work. We have structurally low wages, and this is because the people that need the services, if they have to pay for these services, they also have limited incomes that they have been limited even more in recent years. So when they have to pay for this service out of their own pockets, of course, this creates the pressure to pay workers very low wages. We have long and unregulated hours, significant obstacles to access social protections, even when these are available. Of course, very limited collective organization and representation. There are phenomena of dismissals without protections, dependence on different forms of intermediaries, and of course, difficulties in enforcing rights. I think that this whole picture has been aptly described by the scholar Emma Dolling as a care fix, which is a temporary solution to a structural problem. So outsourcing care needs to badly paid, badly protected, privately hired care workers displaces essentially the social and economic costs of care onto the most vulnerable sectors of society that are working class, often migrant women. Then, am I able to change them myself, or do I need to? No, yes. Okay, so what is the role of law in this picture? First, to say that these problems that I was describing are, of course, complex and are not always just legal problems, and there is a lot of scholarship highlighting that, and several decades of scholars documenting the different social realities that have shaped domestic work in the way it is today. So we have Bridget Anderson's work that talks about the intersection of race and class biases. Martha Nussbaum that has talked about the social stigma that is attached to caring for others, even if when it is for pay. Lydia Hayes, who has talked about care work being constructed ideologically as unskilled, non-productive work. It's offered for free. It's expected to be for free. And what women do out of love and obligation. And this is translated also in the situations where we have paid care workers. We have Adele Blackett that has talked about the unequal law of the private household. And by that, she means different informal norms and actors that shape the regulation, that create the norms about how work within private households should be regulated, what kind of rights are attached and what obligations are there, even though these are not inscribed in the law. But even though there is this very complex social reality, law, I think, still plays an important role by creating and perpetuating not only the extreme forms of abuse, but also the day-to-day routine forms of exploitation. And that I have explored that argument in more detail in the book that Marco mentioned. There I talked about how migration law regimes in different European countries are used to facilitate accessing low-cost private care services. This can be by targeting temporary workers from outside the EU who are in a way encouraged to come here but then face also important legal restrictions once they are in the host country, like having no legal possibility to change employers, restrictions on the right to work in other sectors, no possibility to bring in dependents, no access to permanent residence and citizenship. There are also migration regimes that might restrict entry, but then, of course, people still arrive here anyway, and they turn a blind eye to the lack of legal migration status. We have the au pair regime that has also been explored by others. So different migration law rules and restrictions compound the problems that exist in domestic work and make it even more difficult for migrant workers to access and enforce their rights. As I hinted before, labor laws are often not fit to regulate work in private homes. There are exclusions in national labor regimes, like exclusions of domestic work from health and safety legislation, for example, exclusions from labor inspection, differentiated wages, even inscribed in the law on the visa conditions. There are also partial inclusions, so situations where we may have legislation in place, but only certain parts of that legislation might apply to domestic workers and so on. So all that panorama leaves domestic workers with comparatively less rights than other workers. EU law also has a role in all this. So EU migration law, as I also discuss in my book, it's a very highly fragmented picture, which I think reflects a bias on the value of work. When we look at labor migration directives, we see that highly skilled work, which is conflated with the capacity to earn a high wage, is regulated under better conditions. So highly skilled migrants get better treatment under EU law than those who are termed as low skilled. Protective norms in EU migration law that we can find in these directives, such as the right to change employers or a fast-track access to long-term residence or EU mobility, so the possibility to move from one EU member state to another, is largely inaccessible to low-skilled workers, which will be the case of domestic workers, so they're of no use to them. When we look at the level of EU social or labor law, we will see that there are some provisions that could address some of the problems faced by domestic workers, but these have been largely underutilized. I know the general neglect of paid domestic work at the level of EU legislation and policy making. So despite this very important qualitative role that care work has for European societies, for the sustainability of societies, economies, and so on, but also the quantitative importance that there is a very large workforce there, there is general neglect at the level of EU law and policy. And of course, there are also like explicit exclusions. We can think of here the EU Health and Safety Directive that has excluded domestic workers. And from what I know, it hasn't been reformed to date. Now, the pandemic happened, and of course that showed, illustrated many of these issues that I've talked about, and my colleagues will also highlight. I think everyone came to understand that care is actually very important, and it just happened there. You need people to provide care, and when those arrangements fail, then we have significant problems. In 2022, the European Commission published this policy document, the European Care Strategy, that it's supposed to present the vision of the Commission for the future of care in Europe. There are many elements, I think, in that strategy that are good and worth mentioning. There is, for example, a very wide range view on consideration of this link between paid and unpaid care work, that it's important to look at them together, how when we don't have arrangements for unpaid care work, then that leads also to problems in relation to paid work. There is an explicit link made there between the quality of care and the conditions of work for domestic workers. So we come to understand that if care workers don't have good working conditions, that affects the quality of care that people enjoy in the EU. The strategy encourages member states to ratify the convention adopted by the ILO on 189 on decent work for domestic workers. There is also an encouragement for EU member states to close implementation gaps in the EU acquis. I'm not sure this is the job of the member states. It's rather, I think, also a role for the EU institutions to close these implementation gaps. But okay, the suggestion is there. However, I think there are important limitations in this European care strategy in relation to migrants. So I think the European care strategy largely misses the point when it comes to migration. So I share there a line from the care strategy. It's the opening to one paragraph that is dedicated to labor shortages. Here, the suggestion is that legal migration can be a key driver to remedy labor shortages. And I think this is highly problematic because linking labor shortages and migration tends to essentialize migrants and refugees of certain ethnic origins. There is even an explicit suggestion in the European care strategy that refugees from Ukraine could fill gaps in care jobs, and I think this is highly problematic. I was recently talking to a researcher from Italy who is researching on Ukrainian care workers in Italy, and she was saying how young generation of Ukrainians do not want to be associated to care work at all because, of course, there is this social stigma. So they don't want, she had a very hard time reaching out to them because no one really wanted to be associated to this project that links Ukrainians to care work. But here you have the European Commission suggesting that Ukrainians fleeing the war in Ukraine could fill in these jobs. Of course, by suggesting that migrants should just come here to fill in labor shortages seems to completely miss the point about ethical considerations and the whole issue of care drains that is only mentioned in passing in the care strategy that scholars have identified as a significant problem for sending countries. And there is also a lot of emphasis on skills and training, but I doubt to what extent this is the solution to the problems of care work. So, I mean, you can train workers as much as you want, but if there is no one to pay them a higher wage, then there isn't really that the solution to the problem. Okay, so just to sketch some thoughts there about ways forward, what could be done maybe at the level of the EU to address some of the issues. First of all, I think there's need to be a much more proactive approach on the part of EU institutions on the implementation of the EU acquis in this area. It's important to understand what is happening at the domestic level. By domestic, I mean the national level of the member states. So are domestic workers effectively included in the measures that are implementing new directives, such as adequate minimum wages or the work-life balance directives? What enforcement gaps are there in relation to these new pieces of legislation or to the older ones that are already consolidated? We need to have more scrutiny regarding the compliance with EU law. So to what extent member states comply with their obligations under EU law, because as we have seen, this scrutiny can encourage processes of broader legal change, including also the ratification of ILO that the EU suggests to member states to do, but then doesn't really check to what extent member states are, first of all, complying with EU law. So for instance, we saw that happening recently in Spain with the judgment concerning access to unemployment benefits. So Spain was restricting access to unemployment benefits for domestic workers. The Court of Justice of the EU said that this is contrary to equality. It's an indirect discrimination against this workforce that is mainly composed of women. So it's indirect gender discrimination, sex discrimination. And this judgment also encouraged Spain to, of course, force Spain to change its social security legislation and make unemployment benefits accessible to domestic workers. But at the same time, it also created an impetus for more dialogue at the national level, which then led also to the ratification of ILO convention that also led to more positive changes and legal reform in the country. There's a question there whether we need to be thinking about the need to have a specific directive on the conditions of entry and stay of third country nationals for domestic work. Of course, the danger is there that such an instrument will look more like the Seasonal Workers Directive and not the EU Blue Card Directive, and this, of course, is a problem. But maybe it's a conversation that we need to have. And of course, and I think most importantly, is to be thinking about how care is financed and whether the EU funds could be and how could be mobilized better in order to really finance care in the member states in ways, because I think this is really the only way that we can seriously and fairly address the care crisis we are experiencing. So without that, without adequate funding for care, I think we just we continue the social dumping. So I think this is a very important issue that we need to bring in at the same time as we discuss legal reform in other areas. Financing is also crucial. Thank you all very much, and I'm very much looking forward to comments and questions. I hope I kept the time.
Thank you, Vera. No, it was perfect timing. And of course, plenty of material for the discussion. So be sure to note down your questions as we pass to our second speaker, Maria Sagmeister. Maria is a postdoctoral researcher at the University of Vienna, and she is the main author of a recent report on promising practices for the employment of living care workers in Europe, published in the context of the project Care for Care. Maria, thank you very much for accepting our invitation. So the floor is yours, and I will share your presentation, and you can pass also the slide turner.
Thank you, Marco. Micro is working, right? While Marco is fixing the slides, let me say, first of all, thank you, Vera, for giving us such a wonderful overview over a less than wonderful situation we face at the European level. And my presentation now zooms in to the Austrian case as an example of many of the problems you sketched in your presentation, Vera. So I will talk about circular care migration and social rights, an Austrian case study. Yeah, I see what you mean. This doesn't work. Thanks. Yeah, first, let me give you a brief outline of what I'm planning to do, but the click is not working. Maybe a different. Yeah, okay. Yeah, I was planning to give a bit of a more contextual introduction, but now that Vera already did such a good job, I think we can maybe skip ahead a bit. I still, of course, want to give you in the context of the Austrian situation in its particularities, and then I want to focus mainly on 2 points. Click. One is to demonstrate how the Austrian legal framework actually promotes circular migration. And then the second point, vice versa, how this circular migration then affects the access to social right of the workers in questions. One more click. I also want to mention that what I'm going to present is kind of a follow-up to the Careful Care project Marco mentioned, where we first inquired on promising practices in Europe and then also how an employment model for domestic care workers in Austria could look, before the background that we we're looking for an alternative to the very dominant self-employment model with the involvement of agencies that is in the Austrian market. And we found that even if employment were installed, a lot of problems still arise, specifically in the context of circular migration. So this is why I decided to look into this question in more detail. Yeah, the context, care chains, care drain. I think Vera's presentation covered that. What about Austria? I think you can see Austria as an example for a country very integrated in this context of care migration with some particularities, namely that the most care migration is temporary and circular with quite short work cycles. And it is intra-EU migration. And this is due to geographical and legal factors. Austria is located right in the middle of Europe and borders quite a number of newer EU countries. And especially after the EU expansions in 2004 and 2007, the Austrian care market has become increasingly dependent on cheap labor from Eastern Europe, a dependency that has become particularly clear during the pandemic. Could you click again? I brought a snapshot from Austrian newspaper with the headline, how charter flights hope to at least limit the crash that the closed borders bring to the Austrian care sectors during the pandemic. So today we have around 60,000 mainly self-employed personal care workers and around 900 private agencies organizing these sectors that are registered in Austria today. Yeah, click and you see the exact numbers. More than 90% of those care workers are women, and the majority of those women come from Romania and Slovakia. Typically, they spend work cycles of several weeks in private households of their clients, between which they return home for a similar long period. So this is a circular migration pattern in which people travel repeatedly to a destination country for certain work periods, but the center of their lives remains in the country of origin, to which they return in between. Most of the Eastern European personal care workers in Austria do not aim for permanent migration, and this can also be seen in the context of the feminization of migration, as it is said that female migrants see it as an advantage to be able to return regularly to also better reconcile their care obligations back home with their labor migration. Of course, next to those sociological factors and geographical factors, migration policies and legal frameworks are decisive. As mentioned, EU freedom of movement is crucial for the increase of care migration from women between Eastern and Western Europe, and also between Eastern European countries and Austria. And just to mention that Austria and also Germany even introduced transitional measures that allowed migration into the domestic care sector well before other forms of labor migration followed. So accordingly, most of domestic care workers in Austria are EU citizens. And what I now want to discuss in a bit more depth is how the Austrian legislation actually encourages those forms of migration. From 2007 onwards, personal care in Austria is regulated through the Home Care Act, the Hausbetreuungsgesetz. And according to this framework, domestic care work can be provided either on basis of an employment contract or self-employment, which is a whole different topic, but not the main topic of today. And before the Home Care Act came into effect, the sector was strongly characterized by informality, even though regulation for domestic care workers has been in place in Austria since the 1920s, live-in so-called 24-hour care work with its long working hours never quite fit into those existing legal frameworks. So a new Care Act was designed specifically with these realities in mind, and also to legalize the already common practice of live-in arrangements with circular migrants. It prescribes a specific working time regulation, which differs in central points from the general Austrian labor law, and also from the conventional regulations for domestic care workers that are in place, namely for longer hours and for unpaid standby time. You can click again and again. For today's topic, especially relevant is the applicability of this Home Care Act, which refers explicitly to work cycles of 2 weeks and to live-in setting. The provisions only apply if the worker is accepted into the household for the duration of a work period of 14 days and an uninterrupted leave period of at least the same duration. So in 2/3 of the cases, 2 caregivers alternate to guarantee care for an individual household. And also just to mention what the legislator had in mind is the typical rotation for Slovakia and Austria. Romanian care workers actually have longer care cycles due to longer travel also, but that only on a side note. At a first glance, the setup seems to hold advantages for both the worker, as they do not have to look and provide for a separate residence in Austria, and for the clients due to their factual dependency on a live-in care worker, and also now to the design of the funding landscape. So this also relates very much to what Vera, you said, the financing of care plays an immense role. So the second piece of Austrian legislation I want to introduce is the Federal Care Allowance Act, the Bundespflegegeldgesetz, which generally grants long-term care allowances since the 1990s for people with care needs due to old age, sickness, or disability. And it introduces 7 care levels and determines the allowance level according to the need, regardless of income and assets. To supplement the Home Care Act, an additional subsidy was introduced into this framework in 2007, specifically to finance the newly regulated live-in care arrangements. So one more click. The article of this act prescribes that if a person's care needs reaches a certain level, that is level 3, or in the case of dementia, and if the monthly income does not exceed 2,500 euros, they are entitled to a subsidy for the engagement of a live-in care worker. Eligibility, again, is conditional of the applicability of the Home Care Act, so again, to the rotational work cycle scheme and the live-in setup, and to the qualification of the care worker. Also interesting what you mentioned, Vera. I hadn't thought about that aspect so much. Both subsidies take the form of a cash for care measure, other than benefits in kind, such as the operation of care homes. For example, cash for care provides the recipients with public subsidies, which they can use to purchase care services on the private market. It's a trend in Europe since the 1990s, and it is often commended for fostering free choice. But it must also be seen in relation to the privatization of care work, as you are supposed to purchase your service on a market. And the big disadvantage is that there is little control over how the benefits are spent or how those private structures are structured. And although the legal setup for eligibility in Austria provides minimum standards, mainly the qualification of the care worker, it still gives an incentive for those in need of care to keep the costs of care work low. And as a result, private agencies dominate the market who pay low wages. In the Austrian case, those agencies work mainly with migrants from Eastern European countries. And this also corresponds with international findings that cash for care benefits combined with a lack of public services promote the migrant and the family care model. Click, click, click. So to sum those 2 legislation points up is what we see that Austrian regulation caters to the practice of circular migration between Austria and Eastern Europe with the involvement of private sector agencies. The Home Care Act has created a special regulative regime by focusing on the shared household and the 2-week-long work cycles. And this affects migrants in particular and exposes them to comparatively poorer working conditions. The cash for care benefit stabilizes the dominant position private agencies have taken in organizing those migration patterns and establishing low wages in the sector. So that was the first point. Let's turn to the second. How does this affect the access of social rights of the domestic care workers? The central norm for determining the applicable social security system in cross-border cases in the EU is Article 84 of the Treaty of the Functioning of the European Union. It calls for measures in the field of social security to enable free movement and to ensure that social security entitlements under various national laws are summed up. The corresponding coordination rules can be found in these 2 regulations. And generally, the lex loci laboris principle is applicable. That means that the member state where the person is employed and not residence is decisive. And I chose pension entitlements as an example to go into more depth. And here articles 50 to 60 are applicable. And the main point is that insurance periods completed in different member states must be added together and considered for the calculation of entitlements. So, pension entitlements. In Austria, generally, we have compulsory insurance for self-employed as well as for employed workers. Generally, about 20% of the contribution basis, that is, generally speaking, your gross wage, are paid into a pension. Insurance, of course, here employment, self-employment makes a big difference because for employees, a large portion of this is paid for by the employer, while self-employed workers have to shoulder the whole cost themselves, which is a big burden on care workers' shoulders as they are mainly self-employed workers. So as a result, or not as a result, but in spite of this, pension entitlements are very low. And this is one of the big topics for care worker organizations in Austria at the moment. Here we have a picture from a demonstration stating, wir wollen gerechte Pensionen, we want just pension entitlements. Because the entitlements are very low at the moment, generally in Austria, we have a very large pension gap between men and women, about 40%, 41.6 was the last number I found from 2001. And a recent study by the Chamber of Labor in Austria has explored reasons for this gap. For one, shorter retirement periods due to a lower retirement age, which is now has been changed just starting this year. Of course, high part-time rates and periods of career interruption due to unpaid care work are important factors. However, especially important for the care sector is that low wages and gaps between the termination of employment and the actual retirement in female-dominated sectors are decisive. And the last 2 points, the low wages and those gaps are especially affect workers in the care sector, as healthcare, elder care, and cleaning work are typically sectors that are so strenuous that most people do not work in their professions until retirement age. This results in periods of unemployment in old age and correspondingly to lower pension entitlements. However, to compensate for low pensions, a special bonus is available in Austria, which is very important for women, as you might gather from what I just said. The so-called Ausgleichszulage is a pension benefit from tax revenue to supplement pensions beneath a certain threshold, at the moment 880 euros. So you would get the difference. So de facto, it is a minimum pension. One would think problem here is that this is only available for residents of Austria. And one would think that this is in contradiction to the above mentioned EU regulation. However, it is within legal boundaries because stated in Article 3 in conjunction with Article 7 of the before mentioned regulation, non-contributory benefits such as the Austrian tax-funded bonus can be accepted if classified as a social assistance and listed in Annex 6 of the regulation, which is the case for the Austrian benefit. Care workers, as circular migrants, typically do not spend their retirement in their country of origin and therefore are not entitled to this bonus to compensate for the low pension entitlements. So this is the situation most of the domestic care workers in Austria are confronted with when they return to their home countries in old age, which they are expected to do, and what the whole Austrian setup of this migration patterns ensures. So in conclusion, what I hope to have demonstrated is, for one, how Austrian law not only enables but promotes a circular migration in the domestic care sector, the Home Care Act that has created a special regulative regime, and by focusing on the shared household and work cycle length affects migrants in particular and exposes them to poor working conditions. The Federal Care Act that with the complementary bonus for live-in care work in form of a cash for benefit serves as an incentive for clients to buy cheap care work from private placement agencies who organize those migration patterns. And migration policies and gender also play important part, as domestic care work is highly gendered, and the circularity of migration relates to the feminization of migration. This circular migration patterns affect the access to social rights. While EU regulations are in place, circular migrants face specific challenges and in the Austrian case are exempt from the pension benefit. Thank you.
Thank you, Maria, and apologies for the need to resort to my own help in order to click the slides. Let's see if it works for the next one. Otherwise, you can come here. Let's see. So yes, with that we turn to our in-house speakers. Next up is our very own Catharina Lopes Scodro, who is a PhD student at the CNRS, the French National Center for Scientific Research, and at the European Birds of Passage Project. And as you will see, Catharina's PhD research focuses on au pair migrants and their relationship with employment and social rights. Catharina, you have the floor, and I will set up the slides. Let's see if it works.
Mm-hmm. Okay, yes.
Just a quick switch of chairs. Don't worry. We'll be back in a moment.
So hi everyone, my name is Catharina, as Professor presented, and I'm PhD student in the project. And today I'm going to present a little about au pairs in the scope of EU labor law regulation. And au pairs are often described as young people going abroad to learn a language, to have this cultural experience, and to do so they live in a family's house, provide some housework and childcare in exchange for board, lodging, and pocket money. And their status is very contested in different legal orders and is commonly framed as cultural exchange. But beyond domestic work in one side and cultural exchange in the other, there are some layers that the relationship encompasses. So, for instance, there's legal recognition and status in terms of labor and immigration law, au pairs' self-perceptions about what they do and who they are, what they do, in fact, connected to what families expect and demand from them, and also what the industry, and here I include au pairs agencies and also the organization of those agencies, are arguing for. So my goal, as I mentioned, is to explore more this legal position in EU labor law. So before presenting EU labor law, I will speak a little about the first instrument to regulate the issue in European level. That's the European Agreement on au pair placement by the Council of Europe. In the legislative process of this treaty, it's possible to see that the motivations behind regulating the scheme are commonly connected to situations of overwork, non-off time, no rest days, high demands of heavy work, imbalance between the work performed and also the wage that they receive it, and also the pressure of being part of the family or not. Despite first inclination to recognize a real work contract, the regulation resulted in an agreement that differentiates au pairs from domestic workers based on the purpose of learning and studying a language, even if in the time it was only mandatory to follow courses in France, being part-time, providing domestic help, they do not use the word work, light housework in a differentiation of what would be the heavy housework provided by the domestic staff, no payment since pocket money was not considered as such, not the same border controls and requirements of other labor migrants. Also the temporariness, so the agreement restricts to 1 year that may be extended to 2 years. Age restriction from 17 to 30 years old, and also this discourse of being part of the family. For instance, these pictures, they have been extracted from a physical file used in the legislative process, and okay. Okay, I will continue. In these pictures, it's possible to see that au pairs, they are all white European women wearing some elegant clothes, studying a little bit with technological tools. In here, it's possible to see this attempt to distanciate them from the image of domestic workers and domestic staff, as the word that's mentioned in the model agreement that had been adopted some years later, of the idea that they would use this uniform and so on. The agreement defines au pairs as persons that belong neither to the student category nor to the worker category, but to a special one, which has features of both. Thus, instruments and provisions focused only on workers or students would not include au pairs in their scope. So au pairs are considered more outsiders to labor law in this instrument, and this paves the ground for different treatment, and here I mentioned different rights, to au pairs compared to other workers. Also, it does not bring the dimension of rights, but it only mentions duties in the model contract for families and also au pairs. In the 70s and also in the 80s, that has been a lot of institutional pressures by the Council, but also in the scope of EU institutions to ratify the agreement. As an example, we have this Commission recommendation of 1985. In this instrument, they call for the alignment of national measures regarding au pairs by ratifying the agreement. Nevertheless, when defining au pairs, they do not reproduce the same definition. So they keep aside the part of not worker, not student, but they do include that au pairs constitute a special category which has features of both worker and student ones. Okay, so turning to EU, We have two cases involving au pairs that reached the Court of Justice. The first one was in the 70s, involving a French au pair that spent a time in the UK, and the case questioned if she could be recognized as a worker in the terms of Regulation 1408 on Social Security. And the second one was the judgment from 2008 involving a Turkish au pair, also in the UK, questioning if her period as an au pair could be recognized as legal employment in terms of decision number 1 of the 80s. In both cases, the court decides that there is a compatibility of au pairs and also the autonomous concepts of workers. Also, until the first decade of the 21st century, au pairs have been mentioned in some proposals and also instruments of EU law, mainly to exclude them from regulations to non-EU workers and non-EU long-term residents. In this period, there has been a growing concern with domestic workers' rights. For instance, we have the resolution on regulating domestic help in the informal sector, calling for the recognition of domestic work, even if it uses the word help. But this instrument does not mention au pairs. Also, a few years later, we can see a mobilization in the scope of ILO that resulted in the inclusion of in the agenda of the decent work for domestic workers that started the legislative procedure that resulted in the ILO Convention and Recommendation on Domestic Workers that brings this rights-based approach that recognizes that minimum rights and standards must be met in order to promote decent work for domestic workers. But before ILO adopted these instruments, the standard setting procedure itself starts to produce some effects and impacts in EU. So we had an opinion from the European Economics and Social Committee. We also have 2 European Parliament resolutions. After adopting the convention, the recommendation, there has been the council decision authorizing member states to ratify the instrument, and then another parliament resolution. These 3 resolutions that are in blue, what they have in common beyond the soft law nature is that they do mention au pairs. So now I will present a little bit about them. So the first mention is in the European Parliament resolution on precarious women workers. In this instrument, they state that the European agreement would be from the Council of Europe would be outdated and would not address the au pairs situations and the problems. So it calls for a new agreement, lowering the maximum age of au pairs from 30 years old in order to avoid adult breadwinners to be placed as such. Also, it does not oppose au pairs to domestic workers, since au pairs are in the section of domestic workers, which can represent an effort of dialogue between them, even though it employs different terms to refer to each of them. So, for instance, for domestic workers, it aims to face precarious work, while for au pairs, it refers to the role of help in the family duties. So, at the same time of calling for domestic workers' visibility, it maintains this differentiation to au pairs, positioning them more outside labor law. Also, this resolution is from the same period that countries speaking on behalf of EU member states were manifesting their opposition to consider au pairs as domestic workers in the session of the International Labour Conference. The next one is the resolution from 2011 supporting the, oops, no, sorry. Yeah. Sorry. Supporting the instruments adopted by ILO, that would be adopted by ILO, sorry. This resolution innovates, so it brings some signs of change by including that au pairs are a group of domestic workers who are not often regarded as regular workers. So it establishes that au pairs should enjoy the same protection as other domestic workers. And in doing so, it puts aside the differentiation of au pairs to domestic workers, positioning au pairs more inside to labor law, in the sense that this recognition as domestic workers would make them entitled the same rights. So social security, non-discrimination, equal treatment, protection against abusive practices by employment agencies, training, health and safety protection, maternity protection, provisions on working and also rest time, protection against abuses and harassment, freedom of association and also collective bargaining. So it stands this ILO rights-based approach to all pairs in the scope of EU. And this resolution may represent a watershed in this recognition of all pairs as domestic workers in the EU context, since it does not differentiate them in the terms of rights. But as a resolution, it has limitations since it's a non-legally binding instrument. Okay, then this position is partially reproduced further in the European Parliament resolution on women domestic workers and carers in the EU. This instrument considers the ILO Convention and recommendation using its broad definition of domestic work, and also it recognizes and considers the diverse group of domestic and care workers that comprises au pairs. Oops. Okay. It recalls that au pairs must receive equal protection to other domestic workers, requiring member states to place EU and non-EU au pairs on equal footing. Nevertheless, the resolution stresses the need to ratify the Council of Europe agreement on au pair placement that's based on that definition of not worker, not student. This instrument also calls for the need of formal recognition of au pairs and for more inspections in order to do not let them become informal and cheap substitutes for domestic and care workers. So this instrument presents some incongruences because at the same time that places au pairs as domestic workers who deserve equal protection, so inside labor law, it stresses the ratification of the agreement and at the same time the need for inspections to not let them become substitutes to domestic work. So despite this initial potential to enhance rights for au pairs, it may reinforce the differentiation compared to domestic workers. Also, when it brings this discourse of au pairs becoming domestic workers, in cases where the original proposal is not fully respected, it may represent a risk for whom the domestic work, so the legal status of domestic worker, is an exception when the au pair arrangement fails. A few days after the adoption of this instrument, the EU publishes the new Researchers Directive, which includes au pairs, school pupils, and also volunteers, some of them, as optional categories. Oops. As optional categories. This is the first legally binding instrument in the scope of EU regulating au pairs and is restricted to non-EU migrants. The instrument is inspired by the Council of Europe agreement in terms of definition of au pairs, the use of some key expressions, some as pocket money, host family, and also participation in day-to-day family duties, and also in the content of the agreement to be concluded between au pair and the family. Even though the inspiration in the definition, the directive goes beyond this not worker, not student, leaving open the possibility of member states to consider au pairs to be or not to be in an employment relationship. This approach innovates when identifying through a legally binding instrument that au pairs can be considered insiders in the scope of labor law. But this approach impacts in their right. So for au pairs considered to be in an employment relationship, the new Researchers Directive recognizes them the right to equal treatment in a larger extension. So it comprises a set of rights to non-EU workers of the Single Permit Directive, as working conditions included health and safety at workplace, freedom of association, education and vocational training, recognition of diplomas, certificates, and professional qualifications, branches of social security, tax benefits, access and supply of goods and services, and also services afforded by employment offices. Au pairs considered to be in an employment relationship might also fall in the scope of other EU labor law instruments, Pregnant Workers Directive, Working Time Directive, Working Conditions Directive, etc. But on the other hand, au pairs not considered to be in an employment relationship, they are considered outsiders to labor law. So their right to equal treatment is very reduced to access to and supply of goods and services, and, where applicable, in relation to the recognition of diplomas, certificates, and other professional qualification. So it's very different based on their legal status. Oops. So when looking to the former instruments and the opinions preceding the approval of this directive, it seems possible that ILO Convention 189 on domestic workers served as a turning point in EU labor law to recognize the legal status of workers to au pairs for those being considered to be in an employment relationship, even though legal instruments can also institutionalize precarities for them. And in the new Researchers Directive, this is present in the incorporation of what I identified as a selective rights-based approach. This selective rights-based approach is based on leaving open the possibility of member states to decide whether it is or it's not an employment relationship that impacts both national and supranational legal orders, so not be included in the scope of EU labor law directives. Also, that this possibility structures a hierarchization of legal protection based on their employment status. It also breaks with previous statements claiming for equal protection compared to other domestic workers, and this hierarchization of legal protection is impacted by other factors also that is related to what's considered high and low skill occupations in the same directive. So for instance, researchers, they have the right to stay for the purpose of job searching and entrepreneurship, and also family reunification and family benefits. Au pairs, they do not have. Researchers have some rights that only au pairs considered to be in an employment relationship have. So it creates different layers. The process of increasing au pairs protection, rights, and visibility in EU goes together with the recognition of their proximity with domestic workers. It's possible to see that in EU instruments that little by little this differentiation is being left aside. But this is not the finish line, since the selective rights-based approach means that au pairs not considered to be in an employment relationship have few or almost no rights. Au pairs considered to be in an employment relationship have rights, but they may face the same challenges as other migrant domestic workers in terms of rights and its enforcement. So labor law regulation varies from country to country. Common practices in countries include exempting them from key provisions, and also its intersection with immigration law creates different layers of vulnerability. Thank you.
Thank you, Catharina. And before we switch chairs again, I will somewhat awkwardly introduce myself as the next speaker. Say hi, I'm Marc, and I'm a permanent researcher at the French National Center for Scientific Research and the principal investigator of the European Birds of Passage project. And yes, I have the floor now, so I will move to the computer. All right, here we are, installed again. Okay, so in my presentation, I will, in my turn, zoom in a specific situation. You will see it in a moment. However, I want to use this example to touch on a few points which I believe are important in reconceptualizing some of the elements surrounding domestic and more specifically in this case care work in the case of intra-EU migration and specifically the case of posting of workers. But to start with, a quote from a recent article in the Financial Times, which presents migration as a solution to the labor shortages in unskilled jobs. And of all the jobs, the author Martin Wolf could have thought. Of course, the one example he could think about was care of the old. Now, if you have ever been confronted to the need of caring for an old person, you surely wouldn't mention it as unskilled occupation, not at all, in fact. And we have heard in other presentations the idea of providing training, which is very interesting in terms of providing training for a job which is supposedly unskilled. But I suppose Martin Wolf didn't need care yet. Now, I anticipated in the introduction how we at European Birds of Passage like to talk about migration also for intra-EU movement of workers. And you can see here in the report of 2001 by the European Parliament that while these two categories are separated in the text, they are very much presented as the same supply of labor for care work. So I am comforted, let's say, in my scientific choice by the vision itself that both intra-EU and extra-EU migration provides indeed the labor supply for care work. The interesting points that I want to raise in terms of the reason why I think there is something to be gained in terms of our understanding of this situation by analyzing also situations of intra-EU movement of workers as migration is that there are certain similarities in terms of their vulnerability. Now, there is emerging research of the vulnerability of intra-EU migrants, in particular in the context of seasonal work and agriculture, but many of those can be translated to the sector which interests us today. Indeed, language barrier, often mentioned as a barrier to access enforcement, access knowledge and enforcement of rights, are sometimes even more present as a paradox for intra-EU migrants, because some extra-EU migrants might, as it happens, come from former colonies, so actually share the language of their country of arrival. The knowledge of rights of a different legal system is not necessarily easier for an intra-EU migrant. I know myself having to learn several different systems of, for instance, access to health services and so on. I was not helped, my Italian background particularly, and the access to equal treatment, which is a strong, of course, guarantee of rights, can become somewhat of a hollow provision when you start thinking that many of the sectors where these migrants will work are so-called migrantized sectors, which have intrinsically worse working conditions. So equal treatment can only provide you with the same bad working condition of the rest of the sector. And of course, the paradox is also that from the point of view of the law, they have all the rights, they have equal treatment. And because of that, we have less attention to their situation in policy making, research, and so on. And only recently, for instance, the European Labour Authority has been focusing on intra-EU seasonal workers. And another paradox on this is that in the case of migration, and here I'm talking of migration from third countries, not necessarily for the need of protection of the migrant, but mostly as a tool for control of migration, there is often a requirement to have already a contract of employment or a binding offer in order to access the country of arrival. However, if you are an intra-EU migrant, there is no such a requirement. And while this seems like a facilitation, which it is, it opens up the vast panoply of precarious contracts, bogus self-employment, and so on, because there is no requirement to have an actual employment contract when accessing the country of arrival. And even the right to access the country to find a job can become rather hollow from the moment that this market is dominated by intermediaries. So a single worker moving from a town in some member state, moving to a different one, could not just access any offer of employment arriving in the public square and being available for work. In many cases, it will be through an employment agency. So there is a specific labor market for these intra-EU migrants in certain sectors, and domestic work and care work might be one of them, that makes them closer. I'm not arguing that they are in the same vulnerable position, but they are in a vulnerable position as third country nationals. Now, posting of workers has been one of the responses to a phenomenon which has already been highlighted by other presentations, which is basically the search for cheap labor, be it in domestic or in care work, in this vicious cycle of austerity, wage stagnation, falling purchasing power, and then search of cheap labor from the families. In particular, posting answers this question posed by Martin Wolf when he says, well, some jobs have to be done in the country of arrival, so they can't be delocalized, so that we need migrants. And posting allows this sort of trading non-tradable goods by importing some lower wage conditions. Now, here I will focus on a specific flow. And by focusing on this, I do not in any way want to highlight that this is particularly pernicious, not more than many other flows. But thanks to the excellent research done by the Euro Agency Care Project and by the work of Justina Heimann-Manchewitz from the European Birds of Passage team who has provided me with the data, we can zoom in and show the extent of the phenomenon. Now, the numbers, you see that they are number of postings, which doesn't mean individuals, just means the times where somebody sent. The same person can be sent multiple times per year. And this is often the case, we will see in a moment. And the circular pattern has also been mentioned. So this doesn't mean there are 60,000 to 70,000 people, individuals going there, but there is a number, 60,000 to 70,000 of contracts being concluded for someone to go there. It might be or not be the same person. However, in terms of the share of these are 10%, around 10% of the outgoing postings from Poland. And Poland is one of the main sending countries in Europe. So this is actually a relevant share of posting in one specific sector, which is broader than domestic and care work, but not, let's say, by much. And interestingly enough, an important share of these, not of course, extremely large, but visible, are third country nationals. So again, coming back to this interest of analyzing intra-EU movement also as a form of migration, is that in some cases, intra-EU movers are migrants, are third country nationals, even the strict sense of the word. And all of them, essentially, 90% of these third country nationals posted from Poland are Ukrainian citizens. So also, connecting with this idea that we have found our new supply of domestic and care workers. Now, we have heard already in the presentation also on the role of intermediaries. And interestingly enough, in terms of research at a global level, intermediaries are sometimes mentioned as a sort of second best situation, actually, because while they might have an impact on the worsening of working conditions, on the pressures on the labor market, they also have an impact on the formalization of employment, which might otherwise remain in the informal market. So there is this role for intermediaries, but there are conditions for them to fulfill this role, of course, and this should come with the actual formalization of workers. So workers, to be considered as formal, they should have access to the labor laws and social security laws. Now, the problem with this situation is that in the flow we are looking at, in many cases, the posting happens under what is called civil law contracts, which are, and I apologize if it's not perfect. I'm not necessarily an expert on the Polish labor law, but I do refer to the articles by Izabela Florczak on this point, which are extremely clear. So these are contracts which are, let's say, similar to employment, where somebody is entrusted with the provision of a service for somebody else, but they do not receive the full access to labor laws and social security laws. I will remain at that in the description. If you want more detail, I can provide more details. So the problem with this situation is while intermediaries do make this emerge to formalization in the sense that there is a contract somewhere, this doesn't come with the access to the full spectrum of labor and social security laws. And this is important to remember even in situations which are, in some cases, win-win, where the worker is actually happy to access these labor market opportunities, and the intermediary is very happy to reap the benefits of that, and the family is happy to receive this cheaper service. All right, but this still has an impact and a problem for the situation of these migrant workers, which are kept in this situation which does not lead to a full social security coverage and so on. And we have seen in the Austrian case what this can mean at the end of a career. So it is important in this finding to highlight how these legal uncertainty. So is this always legal? We don't know. We have no case, maybe not. But even in terms of the Polish labor law, this might not be legal. This might be something that should be an employment relationship. But the important point to highlight here, not to put the blame just on the intermediaries and on the bad migrants, is that the country of arrival has a role in absolutely tolerating these practices, because in the end they provide goods which the state has to some extent refused to provide or has retreated from providing in terms of austerity, retrenchment of the welfare state, and so on. So let's not imagine a situation where this happens against the will or the policies of the country of arrival. This is very much known to the country of arrival. Now, what I want to highlight and focus the second part of my reflection on is on the question of temporariness of this migration. And we have seen again mentioned the question of temporariness and circularity and the patterns to which I will come back in a moment. Now, for posting of workers, temporariness is very much a constitutive characteristic. Here I used the word chronotope, and we were discussing with Vera before. It sounds fancy, not so much if you speak Greek as a native language. So the spatio-temporality of posting, why is this relevant in my view, is that this situation of temporariness transforms the spatial and legal situation of the posted worker. It is the fact that this person is there working under this legal arrangement and under this temporal situation that makes its situation different, even though they are physically in this country. They might be under a different legal arrangement, but they are being posted. And so their temporariness justifies a vision, a representation of their situation, which is different from the one of the classic free movement of workers. Now, what I want to focus on is this temporariness real? And how should we address this temporariness and understand it? Now, the funny thing with temporariness of posting of workers is that actually it's a temporariness without limit, okay? Because it is part of the provision of services, and without going into any details about EU law, we know that the member state cannot put a hard limit on the duration of a provision of services. The only need is that there is a foreseeable limit. There is a foreseeable end of the provision of services. Now, of course, there is a foreseeable end if you focus on the individual situation. We have seen the rotation pattern, okay? So there are 2 caregivers. They might be there for a week, 2 weeks, or longer, depending on the organization. But of course, the individual is easily classified as temporary. Okay, because yes, they come and they go, because often they will have family ties, caregiving ties, and so on. They bring them back to their country of origin. However, using, let's say, geographical concept of upscaling, if you go from micro time, so the individual time, to what I have called meso time, which is the time of the business, the time of the operation, you see very, very easily how this temporariness actually disappears, because the worker is posted and replaced with another worker which is posted, and so on and so forth. So is this really temporary? And you might say, Marco, this is just you thinking out loud, doesn't mean anything in legal terms. But I want to argue in my last part is that the law itself actually encourages us more and more to look at the meso time and not at the micro time. Because if you look at the reform of the Posting of Workers Directive adopted in 2018, you have this idea of a duration of posting after which you have access to more equal treatment. Again, no details. But the important point is that if the worker is replaced by another worker, we keep counting. And this might seem minor, and in practical terms often is, because posting on average is 70 days according to the latest data from Frederic de Wispelar and his team. But there is this very idea that we are not looking at the individuals when we are counting this time, that we should look beyond the individual, at the very least at the activity itself, which is performed again and again by a posted worker. And this, of course, should take into account several elements, but here, no problem, because they're literally doing the same job. So all these criteria are easily fulfilled. That's not the end of it, because even under the Social Security Coordination Regulation, which has already been mentioned, under Article 12, we have again a reference to the replacement of the person. So if the person replaces another posted worker, immediately they will be affiliated to the Social Security of the country of arrival. So again, we have to move beyond the individual situation, and not just in our empirical understanding, but in our very legal understanding of what's happening in these situations. And it is important to stress that both these elements have been confirmed by the Court of Justice. The replacement under the Posting of Workers Directive was contested in the action for annulment against the reform of the directive, and the Court of Justice confirmed that it can be done by the legislator, and the replacement condition under the Social Security Regulation has also been confirmed in quite strong terms by the Court of Justice in Alpenrind, where the Court of Justice not only said, yes, if you replace a posted worker with another posted worker, they are immediately affiliated in the country of arrival, but even if a different employer replaces the posted worker to do the same job, in a way preventing a very easy loophole when creating a new company is essentially easy. So I believe that there is in the law these seeds of this different idea of temporariness going beyond the individual level, which I think should help us to change how we think about temporariness and give justice to the actual business situation of this provision of care work in what is an absolutely structural situation in certain member states. And we have seen the example of Austria, and we have seen the example of Germany here. This presence is not an accident of the last year. This is something that goes on. And looking at the meso time, as I have tried to coin for this occasion, using the business time, if you want a less fancy reference, I believe this helps to highlight this role. And the second point I want to highlight for our future research is very much the role of intermediaries, which emerges as incredibly important in domestic and care work provision. And it's still under-investigated from the point of view, in particular, of the role in regulating access to labor markets, where actually, as a migrant worker, be it intra-EU or extra-EU, your access to the labor market is not really limited by your rights, but is limited by your ability to be selected by the given intermediary and be sent there or be sponsored to access that labor market. So in a way, we should update our thinking of the labor market, not in terms of the border of the country where you get in and now you're in the labor market, but more like a legal construction of a chain of intermediaries that will bring you inside this labor market. So that was my last point, and thank you very much for your attention. And I can also open the floor for questions. I already see there is something in the chat. Maybe just somebody leaving. Okay. Yes. For the moment, just somebody leaving. So if you have questions, please raise your hand. I hope I will see it also on Zoom. And otherwise, it's also open. The floor is also open for the room. And of course, I have plenty of questions for my co-speakers in case somebody wants to start. All right. Maria.
Thank you. Yes, just the last thing you said about the role of intermediaries and the labor market not beginning or ending at the border. That is another example for the challenges circular or temporary migrants face accessing social rights is with unemployment benefits. That was the other example we explored for the Austrian case, is that of course, coordination-wise, you are eligible for the Austrian unemployment benefit, but only as long as you are in Austria or looking for a job in Austria. And the whole idea of looking for a job via an intermediary, that perhaps it makes sense for you to look for a job in Austria, in Romania, or in Slovakia through an intermediary, doesn't fit that scheme at all. And so you do not access unemployment benefits because that is just not what the regulation had in mind. I think that is often the problem, that here we have migration patterns that are not a traditional permanent migration setup that the lawmakers have in mind. And yeah, that affects the individual workers very harshly.
Yeah, I will just directly react. I think it's an amazing point. Yeah, because the whole idea of unemployment benefits is that you have to show your link with the labor market where you're asking for your benefits. Can you prove it just by being, registered with an intermediary that provides workers permanently to the member state? Yeah, that we should explore more this argument. Definitely, thank you, Maria.
Thank you. So it's a question for Catharina. I don't know, maybe you know, maybe not, but it's fine. Just to pose a question there. So you were saying about, when you were talking about the researchers directive and the inclusion of au pairs, but only if they are considered to be in an employment relationship. And you said how that leaves open the possibility to member states to decide what is an employment relationship. So it's an issue for, I'm just wondering whether this is really the case or not, or whether there is any scope to argue that, notions of worker developed at the EU level could also apply, because, these new directives in social law that were adopted in recent years, they contain these provisions saying that, yes, to those in employment relationships, having in mind, taking into account the case law of the Court of Justice on what is a worker and employment. So I'm just wondering whether this could apply to this directive or not, or if it's, you may not have thought about it. It's okay.
No, thank you. Actually, I don't have an answer, but I do not remember that in the directive if there is this clause that there are in other directives. But it's interesting to think, since the Court of Justice has already stated that there is a compatibility with other autonomous concepts. So it would be nice to think about it. Thank you.
Right. Now, my question for Vera, because you touched on the idea of the seasonal workers directive for domestic workers, and you know, and you pointed at the Seasonal Workers Directive as a sort of a bad example. I agree in terms it's not a great directive. Still a step forward, maybe?
Yeah, I guess it's better than nothing, but still it's still, I think when you look at the Seasonal Workers Directive, it still allows a lot of discretion to member states, and it's not as strong as to workers' rights. So I see it more as an instrument to facilitate access and not so much as a protective instrument for workers. So this is what I meant, that, you know, if we follow that example, okay, we standardize certain processes, but we don't provide the labor law protection that we will have under other directives that are dedicated to skilled workers.
Yes, of course. I was more talking in terms of, at least there's a strong provision on equal treatment. So that's something. But yeah, of course, I agree. It's a migration directive, so not great for labor law. And I had a question for Vera in terms of something I wondered, looking at the case I presented as well. He said everything is basically done by self-employment situation. Has there been any challenge of this? Because I don't know Austrian labor law, but I suppose we more or less operate under the same definitions of employment, focusing on the power of the employer, organization, the place of work, the time of work. And the power seems to be complete in this situation. There is no freedom at all, I would say, of the supposedly self-employed. Is this something that the law specifically says it's fine?
Yes, it's an open secret that it's bogus self-employment. There's a lot of literature about it, and there has been from 2007 onwards, when the Home Care Act was proposed. Many Austrian labor lawyers wrote about even just the suggested law, that they do not see how this fits with our definition of employment and self-employment. Because, like I said, usually you're so integrated in the organizational structure of the household, and you have to follow orders by your non-employer and so forth. Yeah, it's quite clear, and there are strategic litigation proceedings. It's difficult with funding and everything, but there is a very active self-organization of care workers, and also some unions start to get involved. But the whole relation with the traditional unions and the Chamber of Labor has been difficult. Also because they are self-employed people, but there is some support, and hopefully there will be litigation, and hopefully there will be funding to take it to the EU level if necessary, because what the problem is that politically it is very clearly stated, and also clearly stated in the law, that this is what the legislature wants. We want those cheaper self-employed solutions.
Barbara.
It's more of a comment. You know, I'm also Greek, and it's been 30 years I live in France, and I didn't know what is going on in Greece with informal work and domestic work. But it's a comment and also a testimony, you know. So my father is ill, I went back, and so as everybody, I was looking for a solution. And then I realized what Marco was saying, that there is no care for, there are no structures for old people. And I couldn't imagine how expanded was the use of foreign labor. It's not, it has nothing to do with posting of workers, no. It's people that they are migrants, they are completely illegal, they are completely vulnerable. And I mean, in each little village in Greece, meaning a country that has suffered such a great economic, let's say, horrible situation for a long time, I was so much astonished. And I realized that from one point, the state is not present, and from the other, and not only to regulate and make sure that people pay for social security, you know, for these people, but also that it is completely accepted. People were talking about that, which means that also the intermediaries, I don't know exactly what they are selling, what kind of service they are selling, because they are selling illegal work. It's obvious that they will not afford and pay any social security for these people. I suppose it's the same thing in Italy, no?
Yeah. Daniela, please.
Thank you. Just to present myself, I am from Bucharest, University of Bucharest. Daniela Urse is my name. And to continue with this idea, I was having a question for Vera regarding the affordability of such services, because if we look at countries which are similar from the point of view of development, economic development, we see that the availability and the affordability, especially, of such services is different. Yeah, so I wonder, there are various factors probably here. For example, the taxation policy could be an important aspect, triggering whether this work will be declared or undeclared. And I was wondering if you have taken into consideration such relationship between taxation, social policy configuration, and the vulnerabilities that you are describing in your work. Thank you.
Thank you. I haven't really explored that, but I was wondering if you can explain a bit more, expand a bit more on what you mean about the affordability and availability in a place like Romania, for example, and how that might...
I mean, for example, probably it's very difficult in France to hire someone who will provide care, because the wage level with taxes and everything will be a burden. And this will be affordable for a very thin segment of society. Whereas if we go in another country, like USA, let's say, where the level of taxation will be much lower, the chances to declare that work will be higher, because it's cheaper for the employer to buy such services, for the household to buy such services. So I wonder, so there is a difference of affordability triggered by such factors. And I wonder whether there is a consequence on the vulnerability of the workers, domestic workers.
Thanks. So I didn't look specifically on taxation. Maybe Maria has something to say on that. But I did see, for instance, how sometimes thinking, for instance, of Cyprus now, how a policy of the state and even the legal provisions attached on visas for domestic workers lower the salaries to such an extent in order to make it affordable for the wide population. So we have a situation where people coming from outside the EU to work in this sector will have wage stipulated by the government that it's less than half of what the minimum wage will be in the country. So this, of course, makes it compulsory, essentially, to live in the household, because this is the purpose, is to have someone 24 hours. You provide the accommodation, which helps the worker to some extent, but of course you open the door to other kinds of vulnerabilities and difficulties, and you really locate the worker in a very specific social location in the society. So there are, I think, different ways where legal regimes shape the affordability, but they are not the appropriate. I think we still need to have affordable services, but not at the expense of the people who provide the services.
Yes, I also want to say something for this interesting question. Tax benefits actually function quite similar to the cash for care benefits I explained. So the idea behind that then is that a household is enabled to buy care work from a private market. And that is still not a solution. I think that is still in the area of care fix, like Vera explained. And also in our promising practices study, where one of our main ideas coming from Austria, because also self-employment is a solution to this problem, and a legal one in Austria. It's cheaper to have a self-employed care worker come in, but it's not a good solution. And also employment with the private household and subsidizing this is not the best solution. So what our promising practices study showed actually is that if we're going for employment, we should go for employment with a public service provider and not with a singular household. From a legal level, because in many European countries, we still have a different labor law treatment of domestic workers in the sense of household employees. If your employer is a private household, they are not subjected to the same scrutiny of labor law as other employers are. And also for the individual household, it is a lot to shoulder, not only finance-wise, but also the whole organization to set up, to keep track of tax payments, of vacation times, and so forth. And also to provide long-term care beyond the scope of just an individual household. It's better to have a long-term employer, not a family that needs someone for 10 years until the person cared for dies. And then the person who took care of them is again confronted with problems. And if they were employed with the household, even more so, because then they're unemployed, while otherwise they would just get a new posting.
Okay, any other questions from the room or online? As we are approaching the legal end of our seminar. Okay, if there are no further questions, I will just thank one more time all our speakers, in particular those who have come to Strasbourg to join us. Thank you, Vera. Thank you, Maria. And many thanks to all of you here in person or online for following along and asking questions. And one more thank you to our administrative staff in the person of Sumiach Nini for their support, because of course without them we would not be able to organize anything. And if you're interested in our activities, do check our website. It's europeanbirdsofpassage.eu. And we will organize another hybrid seminar of this kind, this time focusing on agriculture, sometimes in March. And with that said, click like and subscribe, and thank you all again, and have a nice evening.